Hi, I'm Steve Adelman. This is Adelman on Venues. In recognition of Labor Day, which was this past Monday, I'm going to give you a brief discussion on modern labor law, specifically the difference between an employee versus an independent contractor and why that matters. So we're going to have a discussion about what's called agency law. So I prepared a few slides for your edification. And well, first we start with a belated Happy Labor Day. Frankly, I was not working on Labor Day, so that's why we're doing this today. What we're talking about here is agency law. There we go. And the agency law is really the relationship between a principal, which is the boss or the master of a master-servant relationship, the principal, the agent, which is the person doing the work, and third parties, people who are receiving the benefit of that work. So category here, if you're like a student in a law school class, we are talking about agency law. Modern American agency law at least originates from a piece of federal legislation passed during the New Deal, the Fair Labor Standards Act of 1938, when apparently people had to take their lunch on steel girders high over cities. Modern times are governed by the US Department of Labor, and there are basic criteria. Now, normally when I'm approached with the question, is somebody an employee versus an independent contractor, they show me various formalities. So they'll say, the worker has their own LLC, and I'll say, that's great. And they'll show me a document that says independent contractor agreement. I said, that looks like you've got a possible independent contractor relationship, or at least that was the intention. And maybe they'll mention a 1099 or the worker's own liability insurance. And all of these formalities are important, but not dispositive. They don't determine for certain whether someone is an employee or an independent contractor. Here's what does. It's actually something that the US Department of Labor refers to as the economic realities test. What is the economic realities test? In a nutshell, it's control. Control over the means and manner of the worker's work. So if the employer, if the boss gives the worker his or her tools, determines exactly when the worker shows up, where the worker shows up, what kind of work the worker does, provides all the supervision, explains everything, that tends to indicate an employee because the employer is controlling all the means and manner of work. By contrast, if the worker brings all their own stuff, does their own thing because it's their area of expertise and not the employer's, not the principal's area of expertise, that suggests an independent contractor relationship. So let's briefly recap. I don't think this is difficult, but let's make sure. If someone hands you a document that looks like this one and says independent contractor agreement across the top and starts out with verbiage like this independent contractor agreement, the agreement, blah, blah, blah. Steve, does that mean the worker is an independent contractor? What's the answer? Maybe. Maybe. It depends on the degree of control, because the test isn't, do I have a piece of paper called independent contractor agreement? The test is the economic realities between the principal and the agent. That's what determines whether someone is an employee or an independent contractor. Here's why this matters. So back to our three-part graph. So we have the principal and the agent. Let's just start with them. So in the event that the agent gets hurt, say they're, a rigger putting up rigging and they have something fall on them during their work, if the agent is an employee, then their exclusive remedy under US labor law is to file a claim under the Workers' Compensation Act. And workers' comp claims are fairly narrowly confined to certain very specific remedies. By contrast, if the agent is truly an independent contractor, then workers' comp is not their exclusive remedy. Rather, they sue under regular tort law, and the limits of their recovery are what they can convince somebody to pay. So whether an agent is an employee on one hand or an independent contractor on the other matters very much for what kind of recovery they can get in the event that there is a workplace injury. Let's now consider a third party. So now it's during a show, and take that same rigger and piece of rigging. If in this scenario, instead of the piece of steel or whatever it is falling on the rigger, instead it falls into the crowd and lands on the head of some unsuspecting fan, now we have a different relationship. Now the issue is, does the third party know who they should sue? Well, ordinarily, they'll just sue everyone. And you've heard me say that before. Who gets sued? Everybody. But in this instance, we're concerned with who actually would bear liability. What the third party, the person in the crowd, is trying to figure out is who allegedly messed up. And what they'll rely on, so let's say that it's, this good-looking guy. What this good-looking guy will rely on is, can I tell who did the thing that caused me harm? And they will base that decision on, is there either actual authority by the principal for the work that was allegedly done wrong, or is there apparent authority? Does it seem like the person who allegedly did wrong had permission from the big boss? How do you know? Well, sometimes it's as simple as a shirt, a logo on a shirt. So there's my fancy Adelman Law Group logo with the stylized A in the middle of the Coliseum. And if somebody is wearing that shirt, they may have actual authority to do work in the name of Adelman Law Group, but they certainly have apparent authority because they're wearing my uniform. So in that case, the third party certainly can sue the principal. After all, it's the principal's event, but they can also sue the agent because it's the agent's work that allegedly caused the harm. So in a nutshell, there's your agency law primer, and this stuff is important. It's important for recovery from injuries for workers. It's important for potential recoveries and determining who an injured patron is going to sue. It's important for property damage claims. And frankly, it's important because so many times people mess this stuff up. And if you understand who is who, then a lot of these relationships can be altered by contract. Contracts are very important when determining the relationships, the rights and responsibilities between parties. And so that's why we focus so much in contracts on indemnity and hold harmless language, because someone may have liability potentially, but that liability can be pushed away to someone else through a well-written indemnity or hold harmless provision. So these relationships matter on their own. They matter for the purpose of determining liability, and they also matter because a lot of them can be changed by contract. So I hope that didn't hurt too much. That's your Labor Day primer on agency law. Again, I'm Steve Adelman, and thank you for watching Adelman on Venues.